Welcome to another exciting episode of Cash Counsel. My name is Joseph Cordell with the law firm Cordell of Cordell. This show, Cash Counsel, and incidentally note the spelling of that. Some people might get the wrong impression from the spelling. I almost thought when I came up with this title that it was too clever. But it's C-A-C-H-E and then counsel with an E. But in any case, Cash Counsel is a show that's dedicated to helping guys focus on preserving their assets. Now, some of it will relate, of course, to the divorce process directly, but some of it relates to issues before divorce, issues after divorce, issues, to some extent, are totally outside divorce may be applicable. So we try to focus on information that's useful to our clients in helping them preserve their assets. So we thought Cash Counsel was a sort of wonderful thing to add to our general discussions, to all the information that we keep on dadsdivorce.com. We hope that this show will gain a lot of popularity over time. The issue of asset protection is an issue that many people are more and more concerned with in modern times, but also, you know, as we hit some rough spots in the road, and the economy right now is definitely teetering on the brink, if not in fact in a recession. So many people during times like that are worried about issues such as creditors or issues such as employment that can create economic problems. There can be matters such as, do they in fact feel that they're more vulnerable to IRS actions, to actions from those who would potentially sue them, litigants. I haven't seen a study on that. I would suspect that in hard economic times there may be more tort litigation because of the economic incentives. Now, I will tell you, though, that while we do talk about taxes on this show, and we will do things that are calculated to minimize your tax obligations, as I've said before, I don't want you to regard Cash Counsel to have as its centerpiece designing plans to avoid taxes. You don't want to pay a nickel more than you have to, and of course that is our objective, and as a CPA I fully understand that. I just want to be careful and not suggest that these tactics are ways to make the IRS unable to penetrate an entity such as a trust. That has been done before, and it's been litigated. The IRS has aggressively pursued some of those tactics or techniques, and many of them have not withheld court scrutiny. So in any case, I do want you to be aware, though, that we are focusing on trying to preserve assets of guys both inside and outside divorce. Now, having said all that, I gave an overview in the past few shows. If you haven't seen them already, I encourage you to go back and look. And that kind of gives you the aerial view of what is asset protection about. Now I want to go in and focus on each segment that I've talked about and try to explain it more fully. And at the end of this process, hopefully, you'll be able to go to your lawyer and say to your lawyer, look, I'm concerned about asset protection issues, and these are kind of the things I wanted, and this is what I would like to do. Now, your lawyer may possibly shoot down some of those things, may point out some reasons that in your particular case it's not helpful, but you will have a very clear impression of what you would like to do. And those explanations, in the event that a particular plan you had in mind is not workable for you, you'll readily grasp those explanations, and it's much easier to build from there and to move on to a plan B. So I think that an educated client is just wonderfully more capable to be effective in protecting your interests. You can't entirely outsource your self-protection or even your legal representation in key matters such as divorce and asset protection. You need to have some idea what's going on. Now, I thought we would go to the issue of trust. Trust, to some of you, you have some familiarity with you. It's not a sort of spooky term, or it's not something that you think is going to be incomprehensible. Others of you, you've only heard it tossed around some, and often in the context of people who have more money than you do. So it's not something that you have any idea what it involves, and you suspect that whatever it is, it's more complicated than it should be. You may be right about the latter assumption. But I want to talk to you about what a trust is, and I think I can make this very easily understood. I think I can simplify this a great deal, and I hope I don't err on the side of simplicity, but we'll go in stages here. And I guess the first distinction to make when we talk about trust is between trusts that are revocable and trusts that are irrevocable or irrevocable. And the first trust, as it implies, is something where you do create this for lack of a better phrase, entity. you do create a trust and you transfer assets to it, but the law in many ways, certainly from a tax standpoint, does not acknowledge that transaction. So it has no tax significance. If it's revocable, then the perspective of the IRS is that there has been no tangible transfer. And that can apply in some other contexts too. In asset protection, virtually all the state laws, almost all the state laws say if you create a revocable trust and transfer assets to it, that it's fully accessible by creditors that sue you individually because there is no true separation. You've not surrendered control over those assets. So that's a revocable trust. Then irrevocable trust, as the name implies, is something where once you do that transfer, then it is complete and presumably permanent. You can have provisions for modifications in your trust, but not by you. It's going to be by the trustee. Now, theoretically and practically, you can have an irrevocable trust in which you're the trustee. And that's not illogical. Just because you're the trustee doesn't mean that you can choose to undo the trust anytime you want, like you could with a revocable trust. It means that as a trustee, you have to follow the rules of that trust, whatever they are. And of course, they can be very liberal in your favor, but still, this is an entity that you can't just dismiss when you choose to dismiss it. Or to the extent you can, that it ceased to be meaningful as an irrevocable trust. But I would suggest when we talk about irrevocable trust that we think about having them truly separate from you in as visible and identifiable way as possible. And we'll talk about that a little further as we go along. So the first distinctions I wanted to introduce is that between trusts that are revocable and trusts that are irrevocable. So what is this thing called a trust? You know, it's funny, I was at a meeting, a bar meeting, must have been probably a couple years ago, and that's bar meaning the professional association as opposed to the place down the street where you drink alcohol. But in any case, oh, incidentally, they drink alcohol at these events too. But they were talking about the issue of trust, and the question was put before the group, and these are lawyers who deal with this regularly. And the person who was speaking said, so shall we regard a trust as being an entity, like a corporation, this separate thing, or is it a relationship? And you know, it was interesting that you actually got a difference of opinion in the room. And I can tell you that the answer to the question is that it's a relationship. I think that the case law and the advisory commentary and other things make clear that it is a relationship and not an entity. And that's important for reasons we'll talk about later. So when you talk about a trust, really, it's not exactly like a corporation, or it's not like this thing called a limited partnership or other things that that exist independently. But it has some of those qualities, so you might regard it as a hybrid element in the law. But when you think about a trust, really it's a relationship in which one person transfers something to another person's name as trustee. So they're not moving it into an entity, they're transferring it to another person, and that person is taking it not in their own name alone, but in their own name, comma, as trustee. So what you have is a situation where legal title rests in the person that you transfer it to, because if you looked at the deed,